We usually focus on the Second Amendment, but sometimes there's constitutional issues that are in the news that are such a big deal. I think I want to make sure you know exactly what's going on and how to think about them as a constitutional attorney. And that is the case involving this ongoing fight about President Trump being on the ballot or off the ballot because allegedly he is disqualified, according to some, under the 14th Amendment. And I want to break this down again because I think this is so important, and I think a lot of you out there are going to be able to talk about this intelligently as constitutionalists and constitutional attorneys. I want to make sure you have the information you need to be the smartest person in the room on these high-profile constitutional questions. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say I'm a finalist in 2 separate categories for the 2024 Gundy Awards. Thank you for your support. That is for the top male influencer in the Second Amendment space and also for a top voice in the Second Amendment space. I am proud to have made it to the finals in both categories for which I was nominated. Thank you very much for your support on that point. All right, now I'm not going to talk a lot about President Trump and the legal issues associated with him, but there is an issue that I really want to make sure you understand because it just keeps coming up. It's in the news. You're probably going to be talking about this at your poker game or at your gun club or with your friends and family. And I want to make sure you have this constitutional information at your fingertips in case you want to use it. Now, as you know, as of now, there's two states, one Colorado and one Maine, that have both decided, so it seems on its face, that President Trump may not be on the Republican primary ballot in either state. Now, whether you like Donald Trump or hate Donald Trump, that's not the point of this video. The point of this video is I want you to understand how the left in America tries to manipulate the Constitution to mean things and to do things that was never understood or intended to do to advance their political agenda. That is one way, for example, and you may love gay marriage, and that's fine, but whether or not constitutionally there's a right to gay marriage, which is not in the document and is entitled to all these protections, well, that's certainly a serious subject of debate, and a lot of the people that support these unenumerated constitutional rights that simply are not in the document are the same exact people that want to destroy the text-based Second Amendment right to keep and bear arms. So again, I want you to understand what's going on with this Donald Trump is an insurrectionist argument constitutionally, not politically, constitutionally, because it really does teach us how the left will try to manipulate the Constitution into meaning anything they want to get the political outcomes that they so desire. So just to jog your memory, under the 14th Amendment of the United States Constitution, which was enacted in 1868 in the aftermath of the United States Civil War, the 14th Amendment was adopted, and part of it, Section 3, talked about disqualification from holding office. What it specifically says, in essence, as applied to allegedly Donald Trump, it says that anyone who has taken an oath who was an officer, and here's the key language, who was an officer of the United States, who then engaged in an insurrection, who actually engaged in an insurrection or rebellion against the United States, is not eligible to run for, is not eligible to be an officer or involved with the federal government thereafter. Now, with that said, the first question here is, what constitutes an officer of the United States, and does that include the President of the United States? Because Donald Trump, in January 6th of 2021, was the President of the United States. So if he was an officer of the United States who swore an oath to the United States and did indeed engage in insurrection, he might be disqualified. Again, 3 things have to be satisfied. Number 1 is that Donald Trump has to be an officer of the United States, number 1, i.e., the office of the President has to be an officer of the United States in 2021, number 1. Number 2, that he engaged in an actual insurrection, which suggests that there was actually an insurrection or a rebellion. And last but not least, that state officials like Secretary of States and state courts have the authority to effectuate the meaning, to interpret the 14th Amendment and apply it in their states as to who's allowed to be on the ballot as opposed to somebody else like Congress. So those are really the 3 issues. Was Donald Trump an officer of the United States in his capacity as president? Number 2 is, did he basically engage in insurrection? And number 3, who makes that decision? Is it Congress or some other body politic, such as the Secretary of State in Maine or the Supreme Court in Colorado? Those are the three quick questions. So the legal issues here constitutionally are, is Donald Trump, when he was the president of the United States in January 2021, was he an officer of the United States? And it's pretty clear the answer is undeniably he was not. First of all, Chief Justice John Roberts, in a case of Free Enterprise Fund versus Peekaboo, decided several years ago, says that basically the officers of the United States are those that are appointed. You hear what I just said? Appointed to federal office. They're not those that are elected. That is Chief Justice John Roberts, not a radical in any respect, obviously. And that was his conclusion, and that's likely to hold sway in any Supreme Court fight over whether or not President Trump, as president, was an officer of the United States, number one. Then you get to the number two is, was January 6th an insurrection? Now, you can debate that all you want, but the question really is, what does it mean with respect to President Trump? And it's going to be pretty clear that the Supreme Court, I think in a 9-0 decision, if they have to decide this, will conclude that Donald Trump did not engage in insurrection, as that term is defined by the 14th Amendment, for several reasons. The first is, of course, that Donald Trump has already been tried and found not guilty of an insurrection. Keep in mind that he was impeached. He was impeached in January 2022 by the House Democrats, and he was tried in the United States Senate in 2021 for doing exactly what they alleged that he did, which is to engage in insurrection. He was found not guilty. So that's pretty much binding that he did not engage in insurrection. And keep in mind, this is Congress, and there is a decision from the late 19th century that involved the interpretation of the 14th Amendment by the U.S. Supreme Court, specifically by Chief Justice Chase, who was on the Court of Appeals at the time, or well, I won't bore you with the details, but basically Chief Justice Chase at the time says that the only people that have the authority, the only body that has the authority to enforce the 14th Amendment, Section 3, involving disqualification because you were engaged in an insurrection or civil war or whatnot, the only body that can do that is Congress. That has never been overturned. The Supreme Court basically adopted that and agreed with that on multiple cases. That case, by the way, was called the Griffin case. And again, Congress, to the extent they touched fingers with whether or not Donald Trump engaged in insurrection, has already found him to be not guilty by virtue of his 2021 acquittal. So again, the question is, can a Secretary of State's office in Maine or a Supreme Court in Colorado somehow override these decisions by the Congress? And that's highly unlikely. I don't think the Supreme Court will agree with that at all. The next thing is, keep in mind there's major First Amendment issues here. And the First Amendment issue you need to, and this is something I probably should do a whole video on, there's a very famous case called Brandenburg versus Ohio. Brandenburg versus Ohio is a huge First Amendment case by the United States Supreme Court. And in this case, they specifically said, and this is important, that you have a First Amendment right, to openly and verbally advocate for the overthrow, for the violent overthrow, in fact, of the United States government, as long as you do not do it where the actions are imminent. So you can articulate that you think the U.S. government should be overthrown violently. That is a First Amendment right recognized by none other than the United States Supreme Court in the well-established, long-standing Supreme Court precedent of Brandenburg versus Ohio. So even if you wanted to assume for the sake of argument that President Trump was advocating for the violent overthrow of the government, which is absurd because, I mean, I don't think there's any suggestion that he said anything like that. He has a First Amendment right to speak along those lines under the U.S. Supreme Court precedent and the First Amendment. But let's go beyond that. I think the best evidence, in addition to the fact that he was acquitted, and in addition to the fact that you have a First Amendment right under Brandenburg versus Ohio's precedent, keep in mind that I think the most hyper-partisan prosecutor out there today is, of course, Special Prosecutor Jack Smith, who I've done a video as to whether or not we're not even sure he has the constitutional authority or the legal authority to do what he's doing. It may turn out that all of his work goes into the trash heap of history because everything he was doing was essentially illegal because he's not allowed to do what he's doing because the way he was appointed. There's no law under which he's allowed to do what he's doing. But nevertheless, we don't need to get into that in this video. For the sake of argument, we'll assume that Jack Smith has authority to do what he's doing. But keep in mind, there's very few more hyper-partisan prosecutors than Jack Smith, who of course could have brought all these charges several years ago, but decided to wait to the last minute to charge Donald Trump. At least this is how I see it as a professional attorney, that he waited until the last minute to charge President Trump to try to maximize the opportunity to have an actual criminal trial of President Trump in election year in 2024. Now again, you may love Donald Trump, you may hate Donald Trump. This is not the purpose of the video. The purpose of the video is if you really wanted to do justice at the Department of Justice, you would not have waited until a time period where you were almost assured of having President Trump's legal issues that you brought about by virtue of charging him criminally arise and be litigated in 2024, an election year, unless you specifically wanted him to have to deal with these legal problems in the same year that you expected him to run for the White House. It is indeed a kangaroo court / banana republic scenario as I see it. Again, if you wanted to charge Donald Trump criminally, why did you wait so long? But with that said, let's focus a little bit on what Jack Smith has indicted him for in Washington, D.C. The one thing, and this is the dog that did not bark in the night, and that is the one thing Jack Smith has not indicted President Trump for is engaging in anything associated with insurrection. He's not alleged that Donald Trump engaged in insurrection or anything like that. So if anybody had an incentive to indict and charge President Trump with engaging in insurrection or rebellion, if you will, it would be Jack Smith, and he chose not to do that. And this is a very hyper-partisan guy who's being very aggressive against Trump and anyone associated with Trump. Basically, they're overcharging everyone associated with January 6th, so much so that the U.S. Supreme Court has just agreed to hear a case as to whether or not the Maine felony charge that they're hitting all these January 6th defendants with, i.e. that charge that arose out of the Enron financial Wall Street scandals, whether or not a law that arose out of that dealing with the destruction of documents and destruction and tampering of witnesses, whether or not that somehow applies to January 6 people in terms of their interfering with an alleged official proceeding. And I think the Supreme Court is going to throw that law out as applied to the January 6 people. The point is that the DOJ and Jack Smith is hyper aggressive with these January 6 defendants all across the board, including President Trump, but they did not charge President Trump with an insurrection. I think that's all you need to know, that the Department of Justice and Jack Smith does not think they can prove that Donald Trump engaged in insurrection. If you can't prove in any respect that he engaged in an insurrection or rebellion, then obviously the 14th Amendment cannot apply to bar him from running for office. So the last point I want you to just be aware of, and again, I just want to make sure that you have the facts at your fingertips about the Constitution so you can talk about this. The last thing to keep in mind is, let's just think about this for a moment from a procedural point of view in terms of proffering evidence. Now, both the Colorado decision by the Colorado Supreme Court that said Donald Trump's not allowed to be on the ballot, and the Maine Secretary decision, which largely relied, now here's the key, largely relied upon the Colorado decision. Remember how I teach you that every legal win or every legal case is another precedent? It's effectively a brick in the wall to protect our Second Amendment, and that's why even if we win on a gun-related issue in a state court in Idaho, it's great because other courts thereafter can cite to it and rely on it to protect our rights. Well, the left in America does the same thing with their things. So here you have the Colorado Supreme Court relied heavily on the rulings and findings by the House January 6th committee, which arguably was illegal because the Republicans were not allowed to put their people on that committee, but set that technical congressional issue aside. Let us pretend, for the sake of argument, the January 6th committee was a legitimate, real committee with real powers and not illegitimate under the rules of the House. Let's pretend it was real. And they issued all this statements about how Donald Trump did all sorts of terrible things, and January 6th was the worst insurrection ever, which is kind of weird because you would think that if you're engaged in an insurrection, you might have brought at least a single gun, but I don't think anyone did anything like that. So it seems a little odd to me that this would be an insurrection as opposed to a protest that perhaps got out of hand in part. Nevertheless, we're not going to debate that right here. Just something that seemed odd to me as somebody who's sort of watched this from afar. But with that said, so you have the House committee issues this anti-Trump, anti-Republican, anti-conservative statement about January 6th in this long, detailed report. And then what happens is the Colorado Supreme Court relies upon those findings and that work done by the Congressional House Committee involving January 6th. And then the Secretary of State from Maine relies upon the Colorado Supreme Court decision, which in turn relied upon the House Committee, which was arguably not legal because, again, the Republicans were not allowed to put who they wanted on the committee. Those people were rejected, if you recall, and Liz Cheney and Adam Kinzinger were allowed on the committee because that's who the Democrats wanted on the committee. So the Republicans didn't get a chance to pick who they wanted on the committee. The Democrats picked the Republicans, and that's not how it works in the House. But with all that said, you see how the brick from the House went to the brick to the Colorado Supreme Court, went as a brick to the Secretary of State of Maine, and that's exactly how the left does it. But don't worry, because I'm aware of this tactic and strategy, which is why I'm teaching you about it, to advance our rights as freedom-loving Americans and heritage Americans and so on, and those that support the right to keep and bear arms under the Second Amendment. So the last point I simply want to make is the best evidence that the Maine Secretary of State and the Colorado Supreme Court do not actually believe in what they're saying, and these are really hyper-partisan political statements and not constitutional doctrines, or documents, I should say, is the Colorado Supreme Court specifically said that even though they're finding that President Trump is not eligible to be on the ballot, they're not going to allow their decision to go into effect at all, which means he's staying on the ballot unless the Supreme Court acts. So basically they said, we're going to say all these terrible things about President Trump being bad, but we're not going to allow our decision to go into effect until some point in the future. And as a practical matter, I don't think you're going to get to that point. So Donald Trump will be on the primary ballot in March in Colorado, and that's where he is right now. And I don't think that's going to change. Now, as to the Maine Secretary of State, Shanna Bellows, keep in mind she had run for political office as a Democrat and lost, so then she became the Secretary of State, appointed effectively by the Maine legislature. So now she's the Secretary of State, supposed to be a perfunctory administrative bureaucrat, but now she's trying to inject herself into this. But what's interesting is she issued the statement that said Donald Trump's an insurrectionist and is not eligible to be on the ballot in Maine. But then what happens, of course, is she said she's going to stay her decision until a superior court in Maine signs off on it, and that court in Maine has until, I believe, January 17th or so to either affirm the decision or to deny it. And of course, if the Maine courts say that President Trump cannot be on the ballot in Maine, then it's possible the U.S. Supreme Court will have to intervene. But I think there's a good chance that the Maine courts, who are actually going to be responsible for implementing and making this choice, are likely going to reject the Secretary of State's decision because it's such weak tea. All right, folks, and as to what I think will happen is if this gets to the Supreme Court and doesn't become moot and doesn't become irrelevant because Trump wins and he stays on the primary ballot and whatnot, I suspect it will be probably a 9-0 victory for President Trump. I think he will win this case 9-0. There may be some concurrences or some comments from the left on the court, Sotomayor, Kagan, and Brown Jackson, that says Donald Trump is a bad man and we don't condone his behavior, blah, blah, blah. But I think at the end of the day, it's going to be 9-0 that President Trump should remain on the ballots under the 14th Amendment. But this really does teach us in the Second Amendment community, which is why I'm talking about this, how the left in America and those that have a political axe to grind can manipulate and argue whatever they want and manipulate and play with the language of the Constitution in any respect they want to find some hook or angle to get to where they want politically. And of course, the Democrats are the party of, democracy, 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 which of course we're not a democracy in the United States. We are a representative government. We don't want a democracy because, as I've told you before, you've heard in other places, a democracy is two wolves and a sheep voting on what to have for dinner. That is not what we want. That's not what the founding fathers wanted. That's why we have, among other things, separation of powers, and we have a Bill of Rights, and all sorts of things like federalism to try to check the power of the mob rule, also known as democracy. We do not ever want a pure democracy. We do not want a democracy. We want a republic and a limited form of government with fundamental rights and structures that protect minority rights. All right, folks, hope you learned a little bit something here today. We'll talk to you soon here at the 4 Boxes Diner. Make sure you follow me on X at 4 Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.